Hi, good morning. This is Atty. Elvin, and this is my first ever YouTube channel episode, and this is my first one. And the good thing about this channel is that I'm able to communicate to my audience where they see me, and not just read my book or read my blog. So I'm so happy to have this channel to give you some insights on topics that I'm most familiar with. And for this episode, I'll be talking about employee resignation. Employee resignation should be voluntary, especially on the part of the employee resigning. There should be no trickery, force, or intimidation or coercion. Otherwise, the resignation won't be voluntary and there could be illegal dismissal, for which the employee can file an illegal dismissal complaint against the company before the National Labor Relations Commission. Now, under Article 300 of the Labor Code, the employee must observe 30-day prior notice in his resignation. Now, what is the consequence if the employee doesn't observe the 30-day prior notice? Can the employer say that there's no more resignation? No. Why? Because of the constitutional principle of involuntary servitude, which means that the company cannot compel or force or require the employee to keep on working if the employee doesn't want to. All right? So what is the remedy of the employer in such case? It's also provided under the Labor Code in the same Article 300, saying that the employee may be held liable for damages. Now, how much should be the damages? The Labor Code doesn't say. Now, the best approach there is for the employer to have this liquidated damage in the employment contract, which means that there should be a phrase or clause in the employment agreement saying that the employee shall pay the company liquidated damages, for example, an amount of like equivalent to 3 months salary of the employee if the employee fails to observe the 30-day prior notice in resignation, something to that effect. Now, the resignation should be accepted by the employer. The usual habit of companies in resignation is just to make notations in the margin of the resignation letter saying okay or noted. In my view, that doesn't really comply or would be best evidence to show that there's an acceptance of the resignation. As best practice, what I suggest to my friends, to companies, would be to come up with a separate letter of resignation, of acceptance of resignation, and to be served on the employee. And if the employee is not available for personal service, then it can be sent by registered mail to the last known address. Alright, so in my website, www.ebvlaw.com, I discuss more on this resignation, and there are forms available in www.lvsbooks.com on acceptance of resignation, the forms required, the forms needed, like the release waiver and quit claim, and all those other things on post-employment. They are available in the website. So guys, thank you for watching, and I hope to see you next time. Please try to visit the LVS website. Very helpful, most especially to those who are practicing in HR. Thank you very much.